Bob Herbert's OpEd.tv is made possible in part by the CUNY TV Foundation with the support of Ann Ulnick. Hi, I'm Bob Herbert. Welcome to OpEd.tv. We thought the long effort to ratify the Equal Rights Amendment had effectively been defeated back in 1982. Well, not so fast. The issue has reemerged. The fight goes on. And my guest thinks we need to adjust the way we look at the ERA. She'd like us to adopt a perspective that focuses more on the real-world needs of women in the 21st century. What does that mean? We'll ask her. She's Dr. Julie Suk, an expert on the ERA and a professor of sociology and political science here at the CUNY Graduate Center. Welcome. Thanks so much for coming in. I really appreciate it.
Thanks for having me.
So, a lot of us really did think the ERA was dead and buried back in 1982, when the deadline for ratification did not achieve the necessary 38 states at the time. Now we're not sure if that's the case. What happened? What's going on?
Well, after the Women's March in 2017, Nevada went and ratified the ERA in March.
Decades later.
Decades later, 35 years after after the deadline, and 40 years after the last state had ratified it. So Nevada pretty much resurrected the amendment, and it was really led by Senator Pat Spearman, who had some national fame because she gave a speech at the Democratic National Convention in 2016.
Right.
And she is an African-American woman, ordained minister, lesbian who fought Don't Ask, Don't Tell in the military, a mother, and she thought it was time to bring it back. And so the Nevada legislature ratified it. And then between 2017 and 2018, we had the Me Too movement. And I think that played a huge role in Illinois' ratification in May of 2018. And then in Virginia, they had been trying since about 2011, where it would get stuck in committee. But there were legislators in Virginia who'd been trying to ratify it since 2011.
Right.
And they came very close in 2019. And after it failed, again, because it got stuck in committee in one of the houses, many of the women in Virginia made it into an election issue. And in 2019, the legislature flipped, and one of the first things they did when they came back in 2020 was to ratify the ERA.
All right, so you're a lawyer in addition to being a professor. For those of us who are not legal scholars, can you do this? I mean, I didn't realize that you could potentially ratify an amendment with that kind of a gap between states agreeing to ratify.
Sure. Well, there are actually two issues. One is it legitimate to ratify an amendment that took that long, like almost 50 years from the time of adoption and the last ratification? Is that legitimate, right? And we have an answer to that question because the last amendment that we had in our Constitution in 1992 actually took 203 years
oh my goodness.
To ratify. So there's that historical precedent. But the interesting thing about the ERA, there's another legal question because there was a deadline on the ERA.
The one that was passed in the early 1970s, there was a deadline written into, was it the text of the ERA itself?
No. So there was a deadline, but it wasn't put into the text of the constitutional amendment. It was in the introductory clauses in the resolution asking the states to ratify the amendment. And this was something that Congress had been doing for several decades. Deadlines were actually unknown in constitutional amendments until the Prohibition Amendment.
Right.
But when they did the Prohibition Amendment, Congress actually put it into the text of the amendment itself. That
it had to be ratified by a certain time period.
And in fact, in the Prohibition Amendment, the language in the amendment itself says that the article shall be inoperative unless ratified within 7 years by 3/4 of the states. But that language actually changes. That is, at some point, Congress decides not to put it in the text of the amendment itself. So with the 23rd and 24th Amendments to the U.S. Constitution, Congress puts it in the resolution, not in the text of the amendment, and they use different language that says only if ratified within 7 years.
So what do you think needs to take place in order to make this effort viable?
So, well, it's an interesting question because I think that the thing that would make it certain that the ERA can be part of the Constitution is Congress removing the deadline. But I don't think it's absolutely clear legally that Congress needs to remove the deadline in order for that to happen.
So you might be able to have this thing ratified without any congressional action.
Well, it has been ratified by 38 states,
Right.
and now there is litigation. Virginia has actually brought a lawsuit claiming that it's already part of the Constitution because and the legal theory there is that there was no legal effect given to that deadline that Congress put in 1972. And it's because the deadline is worded very differently from previous deadlines that said things that sounded a little more threatening. Previous deadlines said things like only if or shall be inoperative unless. But in the ERA, the deadline says shall be valid for all intents and purposes when ratified within 7 years.
And they did extend it, didn't they? They've extended it once already, didn't they?
Yes, so in 1978, Congress actually voted to extend the deadline, and that's why the deadline that most people remember is 1982. The original deadline was 7 years, which meant 1979, but the extended deadline was 1982. And so the theory is that if they could extend the deadline, the same power that they have to extend the deadline, or even to have a deadline in the first place, because that's not mentioned in the Constitution, if they can have a deadline, they can extend it, they can remove it, they can ignore it.
Right. There was all kinds of support for the ERA, and it looked like it was breezing toward ratification. It looked like pretty much of a done deal.
Yeah.
And then something happened, and that ratification effort got derailed. For those of our viewers, most of whom are too young to remember what happened, explain what went wrong in the late 70s and early 80s.
So there are two things that happened, I think, that derailed the ERA. The first is that a lot of the opponents who took their words from the opponents in Congress, there were actually very few opponents in Congress. It sailed through the House of Representatives in 1971 by well over 90% of the vote. You only need 2/3 in the Constitution, but it was really over 90% of both the House and Senate, totally bipartisan, Democrats and Republicans voting for it. And it goes to the states, and about 30 states ratify within the first year. They think it's kind of a no-brainer that there should be equal rights for women and men in the Constitution. But one thing that happens is that some of the vocal minority within the Senate, when they debated it, really raised a lot of fears. They claimed that they exaggerated what it would do legally. They said that it would mean men and women would be treated the same all the time, no matter what.
Which was not true.
Which was actually not true, and which is not what the proponents wanted. And that's not the version of the ERA that they sold to Congress and for which 90% of Congress voted. But that distortion happened because what the opponents said in Congress got sent directly to Phyllis Schlafly, who was a conservative icon already by the early 1970s.
And a firebrand. I mean, she really, she was a first-rate organizer. I thought terrible issues, but she was very effective at pushing these terrible issues.
Well, she had many talents. She was a great orator. She was a great organizer. And she started a movement called Stop ERA, and it stood for Stop Taking Our Privileges. And she argued that women had privileges. American women were the most privileged women on the planet. And that the ERA would actually take away their privileges as mothers and homemakers and destroy the American family. So that was one thing that I think derailed it, but I don't think Phyllis Schlafly single-handedly derailed it. The other thing that's going on is that there's politics in state legislatures that actually made it very hard for the ERA even to get a fair debate in state legislatures. So Nevada, Illinois, and Virginia are all states that had their battles in the 70s. And in Virginia, it pretty much got stuck in committee most years. And there were just a few guys in committee. There are very few women in the legislature, some of whom were supporters, although some were also opponents of the ERA. But it's really the committees that kept it bottled up. And so it didn't get a fair debate And even though they might have had the votes to pass it, if it actually got to the floor,
Right.
that's something that's very important to the whole story of the ERA, not only in the state legislatures, but also in explaining why the ERA didn't even get anywhere until 1970 and 1971 and 1972, because the ERA at the federal level was bottled up in the House Judiciary Committee for about 15 years before it got a floor debate.
So in the late 70s and early 80s, you had these states where you had the delaying tactics, and they basically ran out the clock. They
Absolutely.
let the deadline expire.
Well, it's not, so in some of the states, there were efforts to introduce it. Illinois is another interesting one, and there have been interesting constitutional questions about this. In Illinois, both houses of the legislature have a rule that says for a federal constitutional amendment, you need 3/5 of the vote. Right. Most state legislatures are ratifying constitutional amendments by a constitutional majority,
right,
or sometimes a simple majority of all those present and voting, right? But there are little rules like this that we never even think about, but that actually make a huge difference, because if you need 60% as opposed to 51%, the kind of coalition and consensus you need to get to ratify it is greater. And that means that it makes Phyllis Schlafly's job a lot easier, because if you could just cause a little bit of confusion.
And she caused a great deal
right,
of it.
Or a little bit of doubt, then it's that much harder to get to 60%.
Now, I mentioned that you and others think that we need to sort of adjust or recalibrate our thinking, our view of what the ERA would actually do. Talk about that a little bit.
Absolutely.
What's the difference between what a constitutional amendment might achieve in the view of people back in the 70s and 80s and in the view now?
So in the 1970s, the Supreme Court had never said that sex discrimination is a constitutional violation. That is, until 1971. Right. And that's why the women who advocated for the ERA said we needed the ERA. We need the ERA because there was all these ways in which states discriminate against women in their laws. There were school districts that would not allow pregnant women to teach school, right? That was sex discrimination. There were a lot of laws that treated men and women differently for the purposes of obtaining credit or administering an estate or exercising other property rights. These were still issues in the 1960s, which gave rise to the ERA. Now, what changes in the 70s is that, in part because we don't get the ERA right away, brilliant lawyers like now Justice Ruth Bader Ginsburg had a strategy where they were making the same arguments for the ERA in cases they were litigating under the Constitution we already had, the 14th Amendment's Equal Protection Clause. And it actually worked. So they had this dual strategy. We're going to advocate for the ERA, and we're also going to argue that sex discrimination is included in the Equal Protection Clause. And Ruth Bader Ginsburg and also Pauli Murray, a pioneering civil rights lawyer, they really developed this legal strategy, and throughout the 1970s, really for the first time, the Supreme Court starts recognizing sex discrimination as a constitutional problem. Right. And it's because of that that now some people are saying, we don't even need an ERA, we already have sex equality. And I think one of the problems with that argument, though, is that it kind of undervalues the work that women did and doesn't give credit to the ERA. The ERA, before it even became constitutional law, or it's not quite part of the Constitution yet, but even while it was just a proposed amendment, it did all this heavy lifting. And I think one of the things that needs to happen now is to just give credit to that work that women have been doing for all these decades. That said, there were a lot of things that people were worried about in the 70s that remain a problem today. And that's a lot of the disadvantages that women face because of their role in childbearing and child rearing. Motherhood is my shorthand for that. And I think these were things that were very much alive in the 70s. So right after the House first voted by an overwhelming majority to adopt the ERA in 1970. And there was it was the 50th anniversary of the women's right to vote. Right. There was a huge women's strike for equality, and one of the central issues was childcare, the need for affordable and available childcare, because equal opportunity for women to work or even be active in politics, all those equal opportunities would not be very meaningful if we did not have access to childcare. And that's something that I think has continued to be an issue, but I don't think it's been resolved as quickly as the issue of striking down sex discrimination in the law.
Now, you've got a book that's coming out, I think, in June, and it's called We the Women, the Unstoppable Mothers of the Equal Rights Amendment. As I understand it, will address some of the issues that you were just mentioning, which talks about the generations of women who actually participated in this effort to get equal rights for women, and specifically an equal rights amendment. So tell us a little bit about your book and what you hope to achieve with it.
So when I talk about unstoppable mothers, I'm referring to the many generations of women who built the meaning of the ERA over time. And I'm even counting the women who tried to stop the ERA, like Phyllis Schlafly, because I think one thing that Phyllis Schlafly did, she by stopping the ERA in the 1970s, I think she really brought attention to the fact that unless the ERA was going to be attractive to mothers in America, it was really not going to go anywhere. Right? And I think that's an important insight because the fact is that 86% of American women become mothers before the end of their childbearing years. And many of the disadvantages that women face in terms of the pay gap and in terms of their underrepresentation in positions of power have to do with a history of excluding women from power because of concern about their childbearing role. And I think that public policy certainly can be doing more to be addressing those inequalities. So one huge issue that really hasn't been resolved at the federal level under the Equal Protection Clause is the problem of pregnancy discrimination and inequalities women face in the workplace because of pregnancy. And there is proposed legislation that has not passed yet called the Pregnant Worker Fairness Act, even though many states, including the 3 states that ratified the ERA recently, have those statutes. But the Pregnant Worker Fairness Act would actually require employers to accommodate pregnant women on the job if it's reasonable to do so. And that's something that I think the ERA could provide a political foundation and political momentum to pass. And then eventually, if anyone were to challenge Congress's power to pass a statute like that, we could say that it's clearly within Congress's power to enforce the Equal Rights Amendment, which is part of the Equal Rights Amendment as well.
Now, you've looked at the some European countries where they have passed constitutional guarantees of equal rights for women. Can you talk about that a little bit? Where has this occurred and how's it been working out?
So it's not just European countries. It's actually, the United States is a real outlier in lacking a constitutional provision.
Why does this happen so often?
That says equal rights for women and men or no discrimination on account of sex. It is a very normal feature of constitutions throughout the world.
Right.
Over 100 constitutions throughout the world have a provision like that. Pretty much every constitution written after World War II has that provision. Now, of course, our Constitution was written much earlier, and that is part of the explanation. And we have a process of amendment that's supposed to improve and update our Constitution over time, but our amendment rule at Article 5 actually makes it difficult to amend. And some comparative constitutional scholars think that the US Constitution is the most difficult constitution to amend. So that explains in some ways why we don't have that provision, but in the countries that do have it, after World War II, women had the vote. And one thing that happens in many countries, not only after World War II, but in Germany dating back to the moment after World War I, women actually get elected to the assemblies that adopt the new constitutions.
Right.
And one of the issues they care about is having a provision that says equal rights for women and men. And certainly in the post-war moments in European countries, they were very concerned about the question of women's role in society. And you saw this in the United States as well, that during World War II in particular, women had to be in the workplace to support the war effort. And I think that really proved to everyone that women could be productive in the economic life of the nation. And frankly, in Europe after World War II and after World War I, it was clear that women would have to contribute to the national economy because a lot of the men were dead. If all the men were dead, if you're going to rebuild a nation after war, and many of the men are dead, it also means that women have to have a role to play as mothers And so public policy is going to have to figure out a way for mothers to work, but also for the children to be raised. And so what you see in European constitutions, Germany, France, Italy, is not only a provision guaranteeing equal rights between women and men, but also a provision that says mothers get the special protection of the state.
To what extent would the passage of an Equal Rights Amendment to the Constitution have a positive impact on those two areas, political representation for women and more of a role in the corporate life of the United States?
So if we follow the European model, one thing that happened in the late 1990s and early 2000s was that they added new constitutional equality amendments that actually said that the law shall promote equal access by women and men to positions of power, or the law shall eradicate inequalities that now exist, right? You get provisions like that in a lot of European constitutions that are amendments that clarify what equal rights between women and men mean. So if we were to take that as a possible model for understanding what equality of rights in the US Constitution means, it would include not only that the state can't discriminate, but also that the state has some responsibility to address the causes of inequality. A lot of countries have taken a fast track by just adopting laws that require equal representation, both on corporate boards and on political party lists in proportional representation elections.
Which would be very difficult, but very difficult to do that here in the U.S.
Difficult, but not impossible.
Are you in favor of that?
I am actually, and I don't think it's so far off in the U.S. because in California, for example, in 2018, there was a law that was passed that requires at least one woman in every corporate board. It's not 50-50, nowhere close to that. But the law,
you can't just have no women.
You can't have no women anymore if you're doing business in California as a corporation. And that's actually been challenged under the 14th Amendment. That is, there are lawsuits that were filed last fall saying that this is a violation of the Equal Protection Clause. And they're building on, the US Supreme Court has interpreted the 14th Amendment to require scrutiny for at least race-based affirmative action, right? And the Supreme Court has used the 14th Amendment to strike down many race-based affirmative action programs that are intended to promote racial equality in many institutions. And I think this is where an ERA could actually step in, because I think that if you look at the 70s history of the ERA, and if you look at what's really motivating the women who are ratifying the ERA today, it's pretty clear that women's unequal position in society is a major issue that they want the ERA to resolve. And if that goes into what we understand the ERA to mean, it means that it would not really make sense to use the ERA to attack affirmative action for women. And in fact, you might even say that the ERA imposes some obligation on states, that is, to avoid abridging equal rights. That might mean that to avoid abridging equal rights, they are going to take positive steps to address severe underrepresentation of women on corporate boards. And once we start thinking that way, that I think that there are ways in which the ERA could help judges uphold laws like the one that's now under attack in
California. And then the ERA would be part of the Constitution, so you wouldn't have the Supreme Court saying that these affirmative efforts to improve this issue or that issue is unconstitutional.
So it would be harder for them to say that if they understood the legislative history of the ERA and use that to give meaning to the words that are in the ERA. But of course, one of the fears about the ERA from all sides of the debate is that the words in the ERA are very brief. Equality of rights under the law shall not be denied or abridged. And those are words that judges will interpret, and those are words that have many contested meanings.
So we've run out of time. I wish we had more. Thank you so much for coming in, Dr. Julie Suk. The book coming out in June is We the Women, the Unstoppable Mothers of the Equal Rights Amendment. We'll be back in a moment with a final word. Katherine Johnson, a genius and a pioneer, has died. Mrs. Johnson, who was black, was a research mathematician who went to work at the National Advisory Committee for Aeronautics way back in 1953. That committee would evolve into NASA, the National Aeronautics and Space Administration, and the research and computations that Mrs. Johnson did at those two agencies, including the development of maddeningly difficult mathematical equations, were crucial to the effort to send astronauts into orbit and eventually to the moon. As the Washington Post put it, Mrs. Johnson codified mathematical principles that remain at the core of human space travel. Mrs. Johnson was among the group of black female mathematicians portrayed in the film Hidden Figures. In 2015, she was awarded the Presidential Medal of Freedom by Barack Obama. Bill Barry, NASA's chief historian, told the Washington Post that Mrs. Johnson was critical to the success of the early U.S. space programs. According to Barry, she had a singular intellect, curiosity, and skill set in mathematics that allowed her to make many contributions, each of which might be considered worthy of a single lifetime. Katherine Johnson was 101 years old. That's all for now. See you next time.